Welcome to our company law class. We are continuing discussion first of the company's constitution. In our last session or the previous class, we explored what the company's constitution is. And we noted that under the Repealed Companies Act, it used to be referred to as regulations. And also, before we came to have regulations under the Repeal Companies Act at 179, under the old Companies Ordinance of 1907, borrowing directly from the English company legislation, we used to refer to the Constitution not as regulation, not as Constitution. We used to refer to as Memoranda of Association and Articles of Association. But the duality or the dual constitutional system actually gave way to a unified system under the Act 179, where we came to have the companies regulations. And the current Companies Act, Act 992, in accordance with maybe development in other jurisdiction in modern times, including English law, we have now abandoned regulations and now we use constitution. We noted that the constitution is not mandatory. We have a default constitution under Act 992, or you can have your own registered constitution. But whatever it is, constitution is supposed to have certain legal effect or consequences. And those were the things we discussed. And before discussing the effect of the Constitution, we also look at the content, that is what should be contained in the Constitution. And if you decided to adopt your own Constitution, the fact that you can provide for what you want to be provided for. However, there are some mandatory things in the law which you must provide. There are some you can vary, others are mandatory. So we look at that. And having looked at that, we came to discuss the legal effects. And we noted that the Constitution constitutes a contract under sale between the company as an entity and all the other stakeholders, members and officers or directors. And again, we also saw that the Constitution is not only a contract under seal between the company and its members and officers, but also a contract under seal between the members or among the members themselves, what do you say, members inter se, and also between the members and the directors, and also among or between the directors inter se, as it were. And we noted that where the Constitution has provided that someone should appoint a director or should remove a director. Now, that is enforceable by that person, and it's an exception to, if you like, the privity of contract rule. If you wanted to apply it to the concept of the Constitution being a contract under seal, that would be an exception. So therefore, if the Constitution has provided that A is supposed to appoint the directors, the person will be able to enforce the provisions of the Constitution insofar as it relates to his right of appointment or removal of an officer from office. And we explain why that may be the case, particularly if the company is going to source for significant funding from someone or entity. The funds provider may want to have assurance that he or she will have a control over those who actually manage the affairs of the company through boardroom deliberations. So he may insist that, okay, put into your constitution that I will be able to appoint a certain number of directors and also have the right to remove them, as it were. So all those things are possible. And again, we noted that where a member or an officer or someone wants to enforce the constitution of the company as a contract, it must be done in representative capacity. Representative capacity in the sense that where you pursue the enforcement, it may not be for your benefit only, but for all those who are similarly affected or similarly, situated, like you. And that is why we said that it's prudent to enlist support of other members or other affected persons. Otherwise, if you single-handedly pursue the litigation, you may have to pay the, you may have to pay the expenses or whatever it is, all by yourself. But if there's a victory, the victory will not be for you only. The victory will be for everyone, as it were. So let us pay attention to that. I think in a nutshell, that is where we discuss up to. Maybe just before we touch on the alteration of the constitution, let's say a few words about how to call shareholders agreement. Shareholders agreement. We have the constitution, but it is permissible for shareholders to supplement the constitution by their agreement. So that is what I want to discuss briefly. Please lock your mic. So we have the statutory constitution, as we have talked about, either the default one or your registered constitution. That is there. But it is also permissible for shareholders to want to supplement the constitution by their agreement. And the question is, why may that be necessary? Why may shareholders want to supplement the constitution by their own agreement? Well, a number of reasons may explain why supplementing the constitution by shareholders' agreement may be necessary, including the fact that if you look at the company's constitution, it's normally available for public inspection because the company's constitution is not private, as it were. You can go to the registrar of companies as part of your search. You can get it because it's a public document, as it were. But the terms of a formal shareholders agreement is a private contract and may not be available for public inspection, and it may also be subject to terms of confidentiality, or what we call the non-disclosure, so that the shareholders have actually committed themselves that let us keep this to ourselves. We are not going to disclose it as it were. Of course, another advantage is the privacy which shareholders agreements provide, because that privacy is missing from the constitution of the company. The shareholders agreement could, for example, include maybe trade secrets or business ideas, but that cannot be included in the company's constitution because the company's constitution is available for public inspection, and you may not want your competitors or others to know you may not want your competitors to know what you are actually uh, doing or using to excel as a company, as it were. So those are some of the reasons why you may want to have your shareholders agreement. And again, in terms of making adjustments, if you have a shareholders agreement, it's relatively cheaper and easier to make, administer, or terminate. Now, if you have a constitution, as you pretty soon be discussing, if you want to amend, if you want to make changes or alteration to the constitution, you have to go through all manner of elaborate procedures prescribed under the Companies Act. But shareholders agreements, they may not be, unless the agreement itself has provided for some particular rigid requirements for making changes. Otherwise, it's relatively easier to get changes done. So in terms of maybe settling dispute or disagreement, being agreement, shareholders agreement can, for example, provide for arbitration, or even they may say that they want any dispute to resolve in a foreign court of their choice, because we've done a private international law or conflict of laws, and then when it comes to contract, we have what you call like the choice of law and then the choice of forum. You can put in the contract that where there's a dispute should be resolved in, let's say, in a court in London or France or South Africa. And because you provided for that in the contract, that will be it. Meaning that you've chosen your own preferred law, as it were. Yeah, so that makes it very attractive. And again, with respect to shareholders agreement, it may provide maybe better protection for minority shareholders rather than just the general provisions of companies act or the company's legislation. And a shareholders agreement may also provide maybe some mechanism for removing minority shareholders and still keep the company as a going concern, rather than having to go to court and, talking about the remedy against oppression. Then the court will have to deploy certain mechanisms in order to get dissentient minority shareholders or shareholders who probably do not agree with how things are being done in the company, either to be bought out of the company and so on. and sometimes where that is even not forthcoming, it may have to necessitate dissolution or winding up of the company, as the case may be. But shareholders agreement can enable shareholders to get around some of these difficulties. Another advantage is that, if you take the constitution to make alteration or amendment of the constitution, you need to pass a special resolution. In the case of shareholders agreement, there is no such requirement. So very easy to achieve whatever adjustment that needs to be done. But we need to also appreciate that shareholders agreement may probably be more useful for private company or a group of shareholders, as it were. We're talking about shares as a topic, and we see what we call the class of shares, where shareholders belong to a particular class or category of shares, and they can make their own arrangement with respect to what we call the class rights as to how their things should be managed. So all those things are possible. So how does shareholders agreement supplement the constitution of the company? So typically, the shareholders agreement may provide for a number of things, but what to be provided for will depend very much on the objectives of the shareholders. What do they want to achieve? What purposes do they want to serve? So in general, a shareholders agreement may cover issues already provided for in the constitution, in addition to other matters of importance to the particular shareholders. So first, it will deal with the objectives of the parties in entering into the shareholders agreement. So maybe we have like a preamble objectives, as it were. The business of the company and how changes to the business may be affected. Maybe shareholdings, how many shares each will have, and so on. Shareholders' loans. There may also be terms of acquisition of additional shares, that after initial acquisition of shares, subsequently, how may other shares be acquired? There may be agreement to that effect. And the shareholders agreement may also deal with governance issues, maybe such as allocation of powers among shareholders, board of directors, managing directors, and management. It may also deal with the composition and appointment of directors of the company. It may also reserve certain matters for shareholders' decision and say that, well, for these matters, shareholders will have to come in before directors can do anything. It may also deal with reporting requirements of management personnel and directors. It may deal with share purchase options, or can also deal with maybe terms of entry into major transaction or corporate restructuring, including mergers and acquisition. They can have their own agreement on how those matters should be done. It may also deal with restrictive covenants. Restrictive covenant, for example, saying that under no circumstance shall maybe the company's business go into this direction or that direction. So that can also be done. Then it may also provide the governing law and dispute resolution mechanism and neither boilerplate or general clauses. Confidentiality clause may be there that nobody should reveal the details, unlike company's constitution, as we have said, is a public document. You can also exclude third-party rights. If you look at the company's constitution, third-party rights cannot be excluded, especially where the constitution has provided that maybe certain persons are supposed to appoint directors or remove directors. That will have effect. But the shareholders agreement, they can say that no, you don't want any outsider to have anything to do with this, and that will be it. So the bottom line is that shareholders agreement can actually provide for anything which is not unlawful, anything which is not prohibited, or which is not forbidden by the Companies Act may actually be provided for in the shareholders agreement. And if there's a provision in Act 992 which actually support this position that I have just canvassed. And if, for example, the constitution of the company, especially where you have a registered constitution, if it is permitted to provide for things which are not in Act 992, so long as they are not lawful, then by parity of reason, shareholders agreement can also achieve the same thing. Of course, being an agreement is subject to what we know in contract, illegality and public policy, isn't it? So just as you cannot have a contract which offends the rules on illegality or public policy, mutatis mutandis, when it comes to shareholders agreement, it can also not offend the rules on illegality. And the rules on illegality certainly will include the Companies Act and related legislation, especially those provisions which are in mandatory terms and say that you shall do this or you shall do that. You cannot actually detract from that as it were. So that is how it is. So if you look at section 26, we look at section 26, subsection 4. Somebody should read that for us, section 26:4.
My Lord, I'm reading.
Right, good.
I'm reading, my Lord.
Yes, proceed. Proceed, Edward.
Section 26:4. A registered constitution may contain any other lawful provisions relating to the structure and administration of the company.
Good. So if you look at the constitution of the company, the registered constitution of the company, in addition to the mandatory content or matters which should be stipulated in the registered constitution, it is permissible for the company in the registered constitution to also make additional provisions, so long as they are not against the law, so long as they are not against mandatory provisions of the law. And that is why we give example that when it comes to directors, for example, depending upon what the company is set up to do, the company can provide some additional comment that maybe if you don't have this educational qualification or this educational background, you cannot be a director of this company. That is not in the Companies Act. However, it is not impermissible because Section 26(4) says that you can actually have other lawful provisions in addition to the mandatory terms required under the Act. So we also submit that by parity of reason or by extension, additional terms may also be provided under the contract that supplement the constitution. No, so long as, please put your mic off, so long as it does not offend the provisions of the law. So let us keep that in mind. But one point we should remember is that a shareholders agreement cannot override statutory powers to amend a constitution. So if you look at the case of Russell against Northern Bank Development Corporation, let me put it there for you. Russell against Northern Bank. I'm putting it in the chat for you. Russell against Northern Bank Corporation Limited. (1992) 1 Law Report 588. So I've provided it in the chat. I don't know if you're able to see it, but it's there. Russell against Northern Bank Corporation Development Corporation Limited, 1992, 1 Law Report 588. It's a House of Laws decision, and it reminds us that, among other things, that you cannot use the shareholders agreement to, for example, override statutory powers to amend the constitution of the company, as it were. And in Russell against Northern Development Corporation, the House of Laws held that an agreement between 4 shareholders of a private company not to vote in favor of an increase in share capital unless they had agreed in writing was valid. They pointed out that the company was not bound by the agreement, but that nevertheless it was valid between the shareholders. So look at it. The shareholders cannot restrict the company. And let's understand this clearly. The company is an entity, and the capacity of the company cannot be restricted by shareholders agreement. The shareholders, as between themselves, among themselves, can make agreement to modify or to restrict how their rights as shareholders are exercised in relation to the company. But they cannot, by that, restrict the company. And that is the ratio of Russell against Northern Bank Development Corporation Limited. And as we were told that we had a private company, we have 4 shareholders, and the 4 shareholders, they had made an agreement, shareholders agreement, that they will not vote in favor of an increase in share capital. Before the share capital can be increased, you need resolution of members. You need the vote of the shareholders before you can increase the share capital. But by their shareholders agreement, they were making the point that we are not actually going to vote to support any increase in share capital unless they had actually made agreement in writing that they should go and vote to increase the share capital. And the House of Law said that, yes, that agreement was not binding on the company. It didn't mean that the company could not increase the share capital. But then, as between the shareholders who will have to vote before a decision can be made that the share capital should be increased, there was nothing wrong with that. And that agreement, to all intended purposes, was valid. So let's get the distinction in that regard. And so the part of the agreement which was purporting to bind the company was actually declared as void because you cannot alter the power of the company to have its constitution or articles of associations amended. So let's keep that in mind. Or maybe another case worth considering is the case of In-Ray Pevery Gold Mines Limited. In-Ray, let me share that with you. In-Ray Pevery Gold Mines Limited. $18.98 on CH 122. Yeah, so In-Ray Pevery Gold Mines Limited, a motion was brought on behalf of two of the shareholders of the company to stay proceedings upon a petition for the compulsory winding up of the company. The petition for the winding up had been presented by a shareholder holding 5,000 fully paid shares. One of the two shareholders held 20 shares, on which 16 shillings per share had been paid, and the other held 13,600 fully paid shares. All the shares were of nominal value of £1 each. It was considered for the purposes of the motion before the court that the petitioner was a contributory who would be entitled to petition, but for provision in the Articles of Association, we provided a quote: no petition shall be presented or proceeded with by a member to wind up the company, except and unless A, by consent in writing of not less than two of the then board, or B, in pursuance or by permission of a resolution passed by a majority at the general meeting of the company, or C, the petitioner or petitioner shall hold or together hold not less than 1/5 of the then issued capital of the company, upon which all costs have been paid. It was admitted during the proceedings that the petitioner had not complied with any one of the conditions mentioned in the clause of the Articles of Association, that's the Constitution, as it were. And for that matter, the judge, the High Court judge at the Court of First Instance, held that although under Section 82 of the Companies Act, that is 1862 Companies Act, laid down that a contributory may present a petition, it conferred a right upon every shareholder just as much as if the terms of the session have been that every contributory should have the right to present a petition. I mean, eventually, it traveled all the way to the House of Laws. And the House of Laws, I'm sorry, to the English Court of Appeal. And the English Court of Appeal, the master of the rules at the time, Lord Justice Lindley, made a statement, and together with the Lord Justice Chitty. And I think that is what is important for our present consumption. Lindley, master of the rules, stated, and I quote, anyone who is familiar with the Companies Act knows perfectly well that these registered limited companies are incorporated on certain conditions. They continue to exist on certain conditions. They are liable to be dissolved on certain conditions. The important sections of 1862 with regard to dissolution are, you mentioned the section. Section 79 states that the circumstance under which such a company may be dissolved by the court, and Section 82 states that the person who may petition for dissolution. Any article contrary to this section, any article which says that the company is formed on the condition that its life shall not be terminated when any of the circumstances mentioned in Section 79 exists, or which limits the right of contributor in Section 89 for winding up, will be an attempt to enforce on all the shareholders that which is at variance with the statutory conditions and is invalid. So in that respect, although not perfectly, the memorandum of association was seen as the major constitutional document, and if you like, the articles of association at that time was seen as internal document which binds the shareholders, and the court was trying to say that you couldn't actually use that to vary that which is provided in the company's legislation itself. And Lord Justice Chitty made a point which is also instructive, and I quote, in my opinion, this condition is annexed to the incorporation of a company with limited liability, that the company may be wound up under the circumstances and at the instance of the persons prescribed by the Act. And the articles of association cannot validly provide that the shareholders who are entitled under Section 82 to petition for a winding up shall not do so except on certain conditions, unquote. So the takeaway from this decision is that where there is a conflict between some of the provisions of the shareholders agreement and the constitution of the company, the shareholders agreement will not supersede provisions of the company, particularly where the provisions of the company are mandated by the Companies Act. If you look at the content of the constitution, some of the provisions are mandatory. So the ones which are mandatory, then the shareholders agreement cannot actually vary it. But if they are not mandatory, as relates to the shareholders, they can actually vary or modify how those provisions operate as among themselves. So let's take note of that. And that is why in our own local case of In-Ray Timber and Transport Kumasi, Crucivac Company Limited, the case of Zatava against Bunsu and another. I'll put the citation there. You can just go and read the case directly from the law report. 1980 JLR 370. says the short title will be the Zastava against Bonsu. Let's say the in-ray timber and transport Kumasi. Yeah, so in-ray timber and transport Kumasi, Crucifer Company Limited, Zatava and Bonsu, shareholders informing the company entered into an agreement that has a clause stating that the agreement should remain irrevocable for 10 years and no member or director of the company formed could present a petition or make an application to the court seeking the winding up or liquidation or in any way attempt to seek to bring the existence of the company to an end. They brought petition before the expiration of the 10 years for official winding up of the company. And at the hearing of the petition, the respondent raised a preliminary objection as to whether, having regard to the clause of the agreement said that you have to wait for 10 years to last before anybody can take any steps for this company to be brought to an end. So the preliminary objection was that having regard to the agreement, the petition for winding up was incompetent. The court upheld the preliminary objection, and the court, which was presided over by Justice Amuasachi, indicated that whilst the regulation, that is the constitution of the company at the time, cannot conflict with the statute, and a company cannot restrict the right of shareholders, contrary to the statute, as between shareholders, an agreement entered will be enforceable. So the court examined the agreement between the shareholders, and Justice Amuasachi held entirely as follows, quote, in the earlier case of Welton against Safri, the House of Laws had agreed that what may not be made a regulation of the company, binding upon all present and future members of the company, may be made the subject of a private bargain between individual members among themselves. In the words of Lord Davey, of course, individual shareholders may deal with their own interests by contract in such a way as they may think fit, but such contract, whether made by all or some only of the shareholders, will create a personal obligation or an exceptio personalis against themselves only, and will not become a regulation of the company or be binding on the transferees of the parties to it or upon new or non-assenting shareholders, unquote. So the bottom line is that shareholders may have an agreement, so long as does not offend mandatory provisions of the law and the constitution of the company, will prevail. Yeah, so that is what we should keep in mind. So having said that, we will quickly look at alteration of companies constitution. How may the constitution of the company be changed or amended? So we are going to look at the section 30. Section 30 of Act 992. So how may the regulations or the constitution of the company be amended? Under the old law, it used to be under section 22 of Act 179, but it has been reenacted now as a section 30 of Act 992. So section 30, subsection 1 makes the point that before the constitution of the company may be amended, a special resolution will have to be passed. So that is the first thing we have to keep in mind, that a special resolution will have to be what? Passed before the constitution can be amended. And what is a special resolution? We have discussed what a special resolution before. Who can remind us of what a special resolution is? Anybody? Okay, go to the eighth schedule. Go to the eighth schedule of Act 992, which is towards the latter part. If you're using the official print, it's at page 374 going. That is the eighth schedule. And the special resolution is at page 384. That is section 14 of the eighth schedule. Section 14 of the eighth schedule, we have resolutions there. So somebody should read for us the types of resolution and section 14 of the eighth schedule of the Companies Act 992. Quickly.
My Lord, I'm reading.
Section 14 of the schedule, of the eighth schedule.
Yes.
Types of resolution. A resolution is an ordinary resolution when it is passed by a simple majority of votes cast by members of the company who, being entitled so to do, vote in person or where proxies are allowed, by proxy at a general meeting. B. A resolution is a special resolution when it is passed by not less than 3/4 of the votes cast by the members of the company who, being entitled so to do, vote in person or where proxies are allowed, by proxy at a general meeting of which notice specifying the intention to propose the resolution as a special resolution has been duly given.
Good. So that is okay for our present purpose. So the section 30, subsection 1 is saying that if we want to pass or if you want to effect amendment or alteration of the constitution of the company, you need to pass a special resolution. And special resolution, we are told, according to the eighth schedule of Act 992, is a resolution in respect of which notice should be given to members ahead of its passage or its meeting, the meeting which will be passed, that they are going to have that special resolution passed. And then on the meeting day, those who will attend, 3/4, which is 75%, should vote in favor of the resolution. When that is done, then special resolution will have been passed, and you can proceed with the particular amendment or alteration that you said you are going to do. So what are, like, once the special resolution is done, if you look at the 31 A and B, it may well be that you are either adopting a registered constitution, especially a company which did not have a registered constitution and chose to use the default constitution at the time of incorporating. Mind you, unlike the old Act 179, it is no longer mandatory for you to have a registered constitution at the time of applying for incorporation. But subsequently, you may find it necessary to have a registered constitution. So where the need arises, then you need to trigger Section 31A by passing a special resolution to adopt the registered constitution. Or where the company had registered constitution, or you want to amend, you want to change aspect of it, alter it, or revoke it completely, you still need to pass special resolution in terms of Section 31A. So let's keep that in mind. But in addition to the special resolution, which is the primary requirement for making alteration or revocation of the constitution, as the case may be, there are specific provisions which require additional things to be done before you can change them, as it were. So, for example, if we take Section 32A, a company's name cannot be altered except with the registrar's consent under Section 21. Again, if we take Section 32B, the number of shares of the company may be altered only in accordance with Sections 9, Section 59 to 65, and then Section 78 to 82, or 219 or 239, as the case may be. Again, Section 30, subsection 2C says that with respect to the business or the objects of the company, it may only be amended under Section 20 or Section 239. Now, when it comes to class rights, that is rights which are enjoyed by shareholders having shares within particular class, that can be changed or amended only under Section 50 and Section 239. Similarly, Section 32F makes the point that Constitution may restrict future amendments. It's possible for the Constitution to, for example, restrict future amendment, as it were. Then we also have a 32H, which makes the point that a member cannot be bound by amendments, increasing liability or restricting transfers without that member's consent. So all these specific rules are meant to provide some procedural safeguards, which were not as robust as we had it under the repeal at 179. But the bottom line is that when it comes to amendments at common law, it should be in good faith for the benefit of the company as a whole, as it were. So you look at the cases like the Greenhag against Arden Cinema. Greenhag against Arden Cinema. The court will remind us that, yes, when you are making alteration, it should be bona fide or in good faith for the benefit of the company as a whole. And then again, the case of DuPaul, Wood Treatment, and Asari, which we should all read. The Supreme Court, we cited it last week. The Supreme Court will remind us that if you decide to adopt a new constitution or change the constitution, you must comply strictly with the statutory form. And in this respect, we're told that the constitution or the company has DNA markers. And DNA markers, for example, who the first directors were, who the subscribers were, or the date of incorporation of the company. These are matters which can never be changed, so that if you decide to even alter the constitution, you cannot change these historical facts. You cannot say that, well, when I came to the company, I've run the company so well, so I think that my name should go into the constitution of the company as a first director. That would be wrong, because that cannot be what changed. So that is what the Paul Wood treatment against Asari is reminding us. So let us pay attention to that. And I think we've cited Akufo and also for Akufo GSC her dictum with respect to the content of the regulation and its amendments before. She spoke in the following terms, quote, "The regulation of a company incorporated in Ghana must have certain prescribed form and content as well as recommended provisions, and may be changed in certain prescribed manner. In the genesis of a company with shares incorporated under the code, there are three significant characteristics that, in my view, may be likened to its genetic markers or DNA. These are the names of the first director of the company, the number of shares of no par value with which the company is registered, and the signature and names of the subscribers to the regulation, as well as the number of shares each is taken and the amount of consideration payable in cash in respect of such shares, duly attested by at least one witness. These are pieces of information that must appear in order to be registrable." And you go on and say that since these characteristics are sine qua non to the formation of a Ghanaian company limited by shares, how can they possibly be replaceable? How can they possibly be replaceable or even alterable after the company has come into legal existence? The very fact that the company has been registered necessarily means that, as at the date stated on its certificate of incorporation, it has these essential markers. A certain number of named persons are its first directors. B, a certain number of shares of no par value of which, one, some or all have been issued to the named subscriber to the regulations in the specified proportions. And two, the said subscriber has undertaken to pay a certain amount in cash or in kind, as may have been previously agreed in writing. These are incontrovertible facts regarding the essential nature of the company at birth and cannot be altered by the registration of a new set of regulations, unquote. Similarly, Justice Datiba, contributing towards this judgment, also made the dictum, which I quote, that furthermore, the document, that is a new regulation, could not have legal effect until registered at the company's registry, and therefore there is need to establish whether there was evidence that it was so registered. The regulation had to be made legally effective first, before powers conferred by them could be exercised to make new appointment of directors, unquote. Yeah, so that is the point. You cannot do alteration to change certain matters which cannot be changed. And again, when you make the alterations or you decide to replace the constitution, it will definitely not come into effect until you have actually have it registered as it were. So let us keep that in mind. Now, just before we go, there is what we call consolidated constitution. It's possible to consolidate the constitution. So look at section 31, where there have been so many amendments. And to know what the position is, you have to come through a lot of documents. it may be necessary to bring all the pieces of amendments together so that we have a consolidated constitution to ensure ease of reference and use. So this will mark the end of our discussion of the company's constitution. So next week, we will move on to discuss membership of companies and then members' meetings. Yes, so we will be in touch again. Have a good morning.